What I'm inquiring about is if a patient was in the hospital and received a broken arm during the process of trying to get blood drawn under the directions of one of the doctors, do you have a personal injury lawyer, negligent?
Okay, thank you for your call. Ruth, your advice.
The interesting part, I think she may have a case, but it's almost kind of a hybrid, Johnny, because it's at a hospital and it's got a medical malpractice component, but it also has the same component as, say, a premises liability type case where somebody was just negligent. But what if it wasn't at the doctor's office, it was just a regular office and somebody broke your arm? Johnny, what path would you tell her to take? Because sometimes it's not 100% clear, but the statute could be different by years depending on what type of case you file.
When it's not clear in that type of situation, you should also always take the most conservative route and treat it that it's going to be a medical malpractice type situation. And because you have a shorter statute of limitations, which is 2 years for most clinics and hospitals, but can be as short as 1 year. And then you also have a requirement to give written notice of the claim, and you have to set out certain factors underneath the statute to make the claim, to make the notice viable. And you have to go through all those hoops and get an expert on board before you can file a lawsuit. So I would treat it as a medical malpractice case and go through all those steps to make sure that you cover all your bases.
Yeah, okay. That's a great point, because say you had a slip and fall at a hospital, and is that a med mal case or is that a premises case? And the difference could be if you go med mal, it's 2-year statute. If you just say it's a regular slip and fall, it's a 3-year statute. But you don't want to sit, like Johnny's saying, you would always want to file that case earlier rather than later.